Today, class, we're going to find the word privacy in the Constitution.
Okay. You find it? No, I was just going to ask you that. I don't know.
Did anybody find it yet?
No. Do we even have a right to privacy?
Yes, we as Americans do have a right to privacy.
But how so? It's not anywhere in the Constitution.
I bet she's lying.
Fake news.
Class, let me explain.
History. In 1890, Louis Brandeis and Stanley Warren wrote a Harvard Law Review article in which they argued that people have the right to privacy. At the time, though, the idea of the right to be left alone didn't hold much weight to it. Despite this, rights that were proposed in this article would become the majority opinion in Supreme Court case Griswold v. Connecticut several decades later.
Connecticut's law. The 1879 Connecticut law provided that any person who uses any drug, medicinal article, or instrument for the purposes of preventing conception shall be fined not less than $40 or imprisoned not less than 60 days. The law also states that any person who assists, abets, counsels, causes, hires, or commands another to commit any offense may be prosecuted and punished as if he or she were the principal offender.
In 1965, a married couple sought out conception prevention advice from a Planned Parenthood in Connecticut. This clinic was run by the head of Planned Parenthood, Estelle Griswold, and Dr. C. Lee Buxton, a gynecologist at the Yale School of Medicine, for giving medical advice on how to prevent conception and prescribing contraception material for the wife's use. Griswold and Buxton were arrested, found guilty as accessories to providing illegal contraception, and were fined $100 each.
The Supreme Court verdict. In a 7-2 decision, the Supreme Court ruled that the Constitution protected the right of marital privacy against state restrictions on contraception. The majority opinion by Justice Douglas ruled that the First, Fourth, and Ninth Amendments create a right to privacy in marital relations. Justices Goldberg, Warren, and Brennan concurred and located the right to privacy was located in the 9th and 14th Amendments. Justice White also concurred, arguing the 14th Amendment was the basis for this decision.
Justices Black and Stewart dissented, arguing that there was no way to infer that the Constitution contained a right to privacy. They dismissed the views of the concurrences that the right to privacy could be found in the 9th and 14th Amendments. Despite dissenting, Justice Stewart thought that the Supreme Court had no choice but to find the law constitutional.
Do Americans have a right to privacy? While it is not explicitly stated or written in the Constitution, we as Americans do have a right to privacy, which is often inferred from the 9th and 14th Amendments.
Not everyone agrees with this, though. Legal scholar Kurt Lash argues that the Supreme Court goes beyond the framers' intentions of the 14th Amendment by using it to constitutionalize rights that were never meant to be constitutionalized. By constitutionalizing rights and taking them out of voting matter, Lash argues that this interferes with the people's decisions about what policies they want to enact.